Well, good morning, good afternoon and good evening, wherever you may be. I'm Michael Cromlin from Melbourne Law School, member of its Centre for Comparative Constitutional Studies, and I'm chairing this evening, as it is in Melbourne, public law seminar on climate change litigation, Sharma, Smith, and beyond. We have a veritable powerhouse of panelists who will address you. The program is organised so that I shall introduce each of them now in the order in which they will present to you, and that will facilitate moving through those presentations before we then turn to Q&A. So each of the speakers has 15 to 20 minutes, and I look forward to seeing your questions at the end of those presentations. Our first speaker is Professor Jason Varuhas, who's Professor of Law at Melbourne Law School, Director of the Centre for Comparative Constitutional Studies. His interests are in administrative law, human rights law, private law, and the law of remedies. And significantly, he's the director of the Public Law Conference, the leading international conference series on public law in the common law world. Second to speak is Professor Geoff McLay from Victoria University of Wellington. Geoff's interests are in torts, intellectual property, competition law, comparative constitutional law, and ethics. Apart from his post as professor at Victoria University of Wellington, Geoff has served as law commissioner between 2010 and 2015. And as the chair of the Legislation Design Advisory Committee's external committee. And then our final speaker is Professor Liz Fisher, who is Professor of Environmental Law at Corpus Christi College and in the Faculty of Law at the University of Oxford. Her interests are in the fields of administrative law and environmental law, and she's published extensively in those fields. She's also general editor of the Oxford Journal of Legal Studies and has served as general editor of the Journal of Environmental Law. Now, Jason will speak on the Sharma case in Australia. Geoff will speak on the Smith case in New Zealand, and Liz very fittingly will speak on a subject that really provides a broad contemplation of the big issues involved in these cases. She has recently been awarded the Leverhulme Major Research Fellowship for 2022 to 2025 for a project exploring legal imagination and environmental law. And that will, I'm sure, inspire many of her remarks. So can I turn first to Jason and then ask both Geoff and Liz to follow Jason's presentation.
Thank you, Michael, for that kind introduction, and good evening, everyone. The focus of my talk this evening, as Michael said, is the full federal court's recent judgment in Minister for the Environment and Sharma. Now, the key question in Sharma was whether the Federal Environment Minister, when deciding whether to approve a coal mine extension, was under a duty of care to take reasonable care to avoid causing personal injury to Australian children under 18 years old arising from carbon emissions. Justice Bromberg in the lower court had held that this duty arose, but on appeal, the full federal court held the minister is under no such duty. and there will be no appeal to the High Court. So first, let me touch on some background to the litigation. So Vickery Coal, a private company, already had planning approval to develop a coal mine in New South Wales. They then sought to expand and extend the proposed mining project. If approved, this extension would, amongst other things, increase total coal extraction from the mine by around 30 million tonnes, which would ultimately produce an extra 100 million tonnes of CO2 emissions. New South Wales state entities had vetted the climate dimensions of the proposed extension and granted development consent, but the extension also had to be approved by the Federal Environment Minister under sections 130 and 133 of the Federal Environment Protection and Biodiversity Conservation Act. Now, it's in regard to the exercise of those statutory powers that it was argued the minister owed a duty of reasonable care to children under 18 years old. So it was argued that the minister, in deciding whether to approve the mine extension, had to exercise reasonable care to avoid causing harm to children in the future arising from greenhouse gas emissions. Now, in terms of the evidence, it was accepted that the extra emissions from the mine would materially contribute to climate change and thus to global warming and adverse weather events, which would lead to harm to children in the future. Ultimately, the three judges of the full federal court unanimously rejected the duty of care, and it is the reasoning of that court that will be my focus this evening. The judgment is complex and spans 900 paragraphs in length. I'll do my best to summarize it and offer some comment. So before getting to the substance of the judgments, let me introduce the duty of care concept. So to have a claim in the tort of negligence, one must establish that the defendant owes you a duty of care. The duty concept is often referred to as a control device, as it delimits the scope of liability. If there is no duty, there can be no liability. Now, the usual approach to whether a duty of care arises is as follows. A court will ask if the case falls into an established duty category, such as that between doctor and patient, or between road users, or manufacturer and consumer. If the case falls into one of these established categories, the duty is held to arise. But in Sharma, the plaintiffs were seeking to convince the court to recognize a novel duty of care. The orthodox approach in such a case is for the court to work from established categories and examine if the pleaded novel duty would represent an incremental development from pre-existing categories. To help determine this question, the court looks at factors which have led past courts to recognize or reject duties. These are known as salient features. This whole enterprise is therefore an exercise in argument by analogy. One looks to material features of past cases to determine if the novel duty would represent an incremental development from existing law. Now, one extraordinary thing about Sharma is that no member of the court works from established duty categories. The members of the court work from various heterodox starting points instead, but not from established duty categories. The failure to properly recognize the nature of salient features analysis is an increasing problem in this field. Courts see the salient features as some sort of acontextualized balancing analysis, but this ignores the fact it's intended to operate as an argument by analogy against the backdrop of pre-existing categories. Now, this point is important in a case such as Sharma, because on this orthodox approach, it seems fairly clear from the outset that no duty should be recognized because the pleaded duty is far removed from any pre-existing category. So because of the heterodox starting points adopted by some of the judges in Sharma, specifically the Chief Justice and Justice Wheelahan, a point to which I will return, The salient features do not, in fact, play a significant role in the determination of the case. However, there is some analysis of these features, and it's important to record briefly what is said in relation to these features, as it indicates impediments to recognition of duties in relation to climate change. So first, the salient feature of control. So for a duty to arise, the defendant must generally have control, some control over the risk of harm. They must be able to do something to mitigate the risk. Now, on the facts of Sharma, on one view, the Environment Minister does have control over the risk of harm because she has the exclusive power whether to greenlight the coal mine extension or not. But for the Chief Justice and Justice Wheelahan, the Minister does not have the requisite control to ground a duty. She may have control over the licensing decision, but she has very limited control over whether the climate catastrophe occurs and its extent, as that depends on myriad variables, including mitigation measures adopted by all nations, which are beyond the control of the Minister. The salient feature of vulnerability generally denotes the ability of the plaintiff class, here the children, to take reasonable steps to protect themselves. If there is no way they can protect themselves, this favors recognition of a duty. Now, on one view, the plaintiffs are vulnerable as there's nothing they can do realistically to affect the Minister's decision or of themselves avert the climate cataclysm. But for the judges, what was relevant is that the children were not specially vulnerable. They do not suffer a particular vulnerability that marks them out from anyone else who might suffer from the effects of climate change. Turning to indeterminacy, for a duty to arise, one needs to be able to determine the plaintiff class. So one needs to be able to state to whom the duty is owed. In Sharma, the plaintiffs argued the relevant class was Australian children under 18 years old. But the problem was that there's no rational reason for so limiting the class. Why should the duty not be owed also to the unborn who might suffer the effects of climate change, or children overseas, or anyone who'll be alive when catastrophic climate effects materialize? Now, the point is, it's very difficult to identify one group that will be especially affected, which in turn means the duty would effectively be owed to the world at large or the public at large. And that is impermissible on established tort doctrine. I note in passing that no one has really been able to justify the indeterminacy criterion, but that's an issue perhaps for another time. Now, turning lastly to proximity. Proximity denotes the idea that there needs to be such a closeness of connection between plaintiff and defendant so that the defendant ought to have the plaintiff's interest in their contemplation. Now, in Sharma, Justice Beach in particular relies on this notion to reject the duty. He considers there's not a sufficient closeness between the minister and the children to found a duty of care. But the problem here is that the High Court has rejected the concept of proximity, specifically because it provides no practical guidance. So on that basis, one may query Justice Beach's reliance on that concept. Now, one of the biggest issues that comes out of the Sharma case, and particularly the Chief Justice's judgment and Justice Wheelahan's judgment, is the role of statute in determining whether novel duties of care arise. For these judges, the statute conferring discretion on the minister is the starting point of analysis in deciding on duty, and indeed the end point. So in the Chief Justice's judgment, the salient factors which I've just analysed, such as control and vulnerability, are given cursory, if not tokenistic treatment. For the Chief Justice, everything comes down to the statute. Now, there are several problems with this approach. First, it's a subversion of the established framework of principle for deciding duty questions, which starts with established duty categories and works through all the relevant salient features to develop an overall picture of the nature of the relationship between plaintiff and defendant. In the Chief Justice's judgment, he defines the relationship only by reference to the statute. This ignores features such as control and vulnerability, which are designed to pick out normatively salient features of the relationship, and therefore the analysis is incomplete. Second, the statute-centric approach involves a category error. The judges in Sharma are looking to the statute to see whether it can support a duty of care. That is the wrong inquiry. The question is not whether the statute positively supports a duty. That is to get things the wrong way around. The question is whether the common law tests in the law of negligence support recognition of a duty, and the statute is one aspect of those tests. The approach taken by the judges would be more at home in the separate tort of breach of statutory duty, where the duty is sourced in the statute itself, and therefore one looks to the terms of the statute to see whether an action arises. Now, thirdly, the narrow focus on the statute led the Chief Justice to the conclusion that there is no private law relationship between the minister and the children, but rather their relationship is a public law relationship between government and governed. But every statute that empowers governments to do things in the public interest could be described in that way. If followed to its logical conclusion, this analysis could deny the operation of negligence in most statutory contexts, but as everyone knows, that is not the law. So the mode of analysis, to my mind, is rather surprising, given the salient features approach has been in place for over 20 years, and there are very clear statements of principle as to how the analysis ought to proceed, such as Justice McHugh's judgment in the High Court Authority of Criminals. So the general approach of the judges is questionable, and it's notable that Justice Beach, the third judge on the panel, does work methodically and seriously through all of the salient features. The requirement that a duty of care must be consistent with the parent statute is one salient feature that ought to be considered once all other features have been worked through, so that when one asks whether the pleaded duty is consistent with the statute, one has a clear idea of the nature of the duty. So I think the general approach adopted is questionable, but having said that, consistency with statute is nonetheless one salient feature in the salient features analysis. And I do agree that it tells against a duty in this case. Now, the reason is that overlaying the pleaded common law duty on the statutory scheme distorts the focus of the Act and the minister's discretion in such a way that the duty can be said to be inconsistent with the scheme. The statutory scheme is concerned with particular environmental matters, such as water resources and endangered species, but not overtly with greenhouse gases. So to impose a duty in relation to climate change would be to make that a central or controlling factor in a statutory scheme where climate change is scarcely mentioned. Also, the minister's statutory discretion is regulated by a detailed code of considerations. Climate change is not specifically mentioned, but the effect of recognizing the duty would be to make that a central concern in the exercise of the discretion. Now, the corollary of that analysis is that in a different statutory context, in which protection against climate change was a core concern, a tort duty in relation to climate change could potentially be recognized. If the legislation was dedicated to protecting a specific group against climate change, then there would be a strong case for recognition of a duty of care in favor of that group. Further, if a statutory discretion in a different scheme was open-ended and broadly framed and not governed by a detailed and closed scheme of mandated considerations, there'd be more conceptual space for a duty of care to be recognized. Now, a core and determinative reason for rejecting the duty, stressed by the Chief Justice in particular, is that climate change raises policy questions that are properly for democratic institutions and government. The point is repeated many times, and a series of broad statements are made to that effect. Now, to my mind, the statements are not especially productive. Many things are properly for government, such as provision of police, prisons, and healthcare. It doesn't follow necessarily that government cannot owe duties to avoid causing harm in those contexts. So let's focus in then on some more recognized legal concepts that were relied on by the judges. So the Chief Justice and Justice Wellington rely on the policy operational division to reject the pleaded duty. This is the idea that if a statutory power involves policy making, no duty can arise, but if it involves implementing a policy or operationalizing a policy, then a duty could potentially arise. Now, this concept is, as I say, invoked by the judges to reject the duty. But 2 points can be made in response. First, the policy operational distinction has been discredited by the High Court because it's proven impossible to draw. So it's surprising to see it make a comeback. Second, in Sharma, the minister's power is not one to create climate change policy. It's a power to license a mine. The exercise of the power may draw on or apply government policy, but this is surely to operationalize policy rather than make it. Second, the judges invoke the idea of core policy, a concept that has been relied on by the High Court to deny duties on government in some cases. But that notion has a specialized legal meaning. As an exception to liability, it's very narrow, and it has generally been said to be limited to budgetary decisions and legislative decisions. The statutory discretion in Sharma is neither a discretion to allocate resources or to make a legislative instrument. And further, as Justice Beach observed, this factor has only generally arisen in omissions cases, whereas Sharma is a case of positive acts. Now, thirdly, the judges rely on the idea that a court should not recognize a duty where in deciding on breach of duty, so in adjudicating whether the duty had been breached, the court would necessarily be drawn into matters beyond their competence. But the problem with this analysis is that the judge's analysis is entirely speculative. We don't know in any given case what the breach inquiry will involve. And further, if at the breach stage it happens that issues arise which are not properly for courts, the court can simply defer on those matters. That's what happens in judicial review. Courts very rarely today say that a whole area of activity, such as climate change, is beyond competence and immune from legal scrutiny. Rather, if issues happen to arise which are beyond judicial competence, the court can modulate its approach accordingly. Now, similarly, in a medical negligence case, the court does not say there is no duty at all because the judges are not experts in brain surgery. Rather, in judging whether reasonable care was taken, the court defers to established medical opinion. Now, in my view, these legal tests, properly applied, do not operate to rule out a duty in Sharma, but at least two of the judges in Sharma obviously took a different view. Now, in addition, the breadth of some of the Chief Justice's statements in relation to the policy exception are surprising. And if taken literally, they could be taken to suggest that wherever there's a matter with some policy dimension, the matter is not for the courts. I have a great deal of respect for the Chief Justice. He's a distinguished jurist, but the breadth of the statements made in Sharma are contrary to authority and to principle, and they also raise serious rule of law concerns. If taken literally, the statements raise the spectre of vast areas of government activity being outside judicial competence. This is to create legal black holes within which government can abuse its power and harm people without those people having legal recourse for that harm. These statements were also unnecessary for determination of the appeal because the case could simply have been dismissed on application of the orthodox salient features. So, some reflections, some final reflections. So first of all, what did the litigation achieve? Obviously, the claim failed, but even losses can be productive. In the course of the litigation, the courts held on the basis of unchallenged evidence that climate change is real and will lead to a cataclysm if steps in mitigation are not taken. The litigation might be seen as one plank in a broader social movement to bring pressure to bear on government. It generated a lot of publicity. Whether the pressure changed government thinking or policy is something that needs to be properly investigated. One counterproductive aspect of the litigation is that because the first instance decision from Justice Bromberg was rather bold in that it pushed the bounds of established principle, it seems to have elicited an overcorrection from the full court. As noted, some of the statements made, if taken literally, might be taken to rule out climate litigation altogether. And as I've observed, with respect, many of those statements are overly broad and unnecessary and raise rule of law concerns. As a matter of doctrine, it's concerning that the salient features approach that's been embedded in Australian doctrine for over 20 years is not well understood. It's also surprising that concepts such as the policy operational divide and proximity have made a comeback despite being disapproved by the High Court. Notwithstanding these criticisms of the judgments, it's clear there are real challenges for climate litigation and negligence. Putting aside the policy exception and the role of statute, the fact is ordinary salient features such as control and indeterminacy will pose a persistent impediment to recognition of duties in relation to climate. Justice Beach, in his judgment, did recognize that certain concepts such as indeterminacy may have reached their shelf life. But the problem is judicial legal development is slow and incremental. That's the nature of the common law method. So even if it's accepted that certain principles are problematic, it may take time for the law to shift and radical change is unlikely. Courts tend to be cautious to keep liability in check. Now, lastly, I feel compelled to say something about the length of the judgment. It's nearly 900 paragraphs. That's 200 pages. There's no reason why it should be so long. There is no new law being created. The court is applying established jurisprudence. There were no serious factual controversies to be resolved. The court had to decide one single central issue, and all judges concurred in the result. The length of the judgment undermines the rule of law because it makes the law inaccessible, and it does so in the context of an issue of great public interest. So I better stop there and pass over to Professor McLay.
Tēnā koe, Jason. Tēnā koutou katoa, everybody who's listening to me now, hopefully. So the reason I'm showing you the slide, there are two reasons. The first is that we're always trying to convince Jason that he's made a mistake in living in Melbourne and he should be living in his beautiful home city. The second is that the Smith litigation, if it's about anything, is about a sense of place. And this is my place. One of the things you'll notice about Wellington, those of you who haven't seen Wellington before, is that there are a lot of hills, but essentially all of the flat land in Wellington is either earthquake seabed, which rose in an earthquake in the mid-19th century, or reclaimed land. And in fact, the building which I'm talking from is entirely built on reclaimed land. And in fact, down below us is just seabed, and there are pumps downstairs. So the sea is very much part of our lives, and one can imagine, doesn't have to imagine very much what would happen to our city in any significant ocean rise. And we've just had a study in New Zealand about the effects of ocean rise on cities like Wellington and Auckland. So that's the sense of place. I also always just like to share the picture from my window. which is, for those of you who haven't seen this before, is the executive wing, the beehive, where the decisions are made, and the legislative building just behind it or to its side. And I just wanted to make the observation in showing you this picture that I think New Zealand is in a different place, at least rhetorically, in climate change than we understand Australia to be. So in New Zealand, it is not possible for a major political party leader to stand up and to deny climate change or to in any way, shape or form say that the government should not be committed to dealing fully and adequately with climate change. Both the Prime Minister and the Leader of the Opposition are very clear about that. New Zealand is publicly committed to dealing with climate change, but like all of those public commitments, there are disputes obviously about whether there is enough being done. There is particular controversy in New Zealand always about the exclusion of agricultural emissions, also known as animal farting in our jurisdiction. There's a functioning emissions trading scheme of various utility, depending on who you listen to. There is a climate change commissioner who is looking into the setting of emission targets. That report that has been issued is subject to a separate judicial review, which we're waiting the results of. Basically, a group of lawyers saying they didn't do enough, wouldn't take climate change seriously enough. So I think there's a public context in New Zealand where there is a general commitment to change things. But the question in the Smith litigation is whether things are being changed enough. So I just think it's important. What I've done is try to take slabs from the judgment. I think it's just really important to start off with who Mr. Smith is, because that's, I think, the central element of this case, which is probably different in some ways from what you've got in Australia. Mr. Smith is an elder of Ngāpuhi and Ngākahu. So Ngāpuhi is the major tribe in the top third of the North Island. It is by far the most populous tribe, iwi, in New Zealand. He is a representative on the Iwi Shares Forum, which is the forum of what you would call tribes. And essentially he claims that he is a traditional owner of land which is being affected now by climate change and will be greatly affected by climate change in the future. So what he's suing for is his sense of place and the effect that government policy is having on that set of place. But in particular, and what's different about the New Zealand case is that the effect that private emitters are having on his sense of place. I just need to set out who these people are, because I think many Australians probably think that all business in New Zealand is small fry. New Zealand's a small place. When we see Fonterra is one of the largest dairy companies in the world. It's, I think, the only large-scale exporter of dairy products that makes money. It is very dominant in the New Zealand economy. Fonterra is joined in the action by the electricity company that has our thermal electricity generation. Most generation in New Zealand is hydroelectric or geothermal. There are still some thermal plants. There's a large publicly, as it turns out, publicly owned service station company that runs a network of service stations, and our one and only oil refinery. And according to the plaintiffs' lawyers, this makes up about 1/3 of the total New Zealand emissions. So many of the big players in the New Zealand context are here. Of course, that's 1/3 of New Zealand emissions. That's not 1/3 at all of world emissions, given our place in the world and our reality in our world. But from a New Zealand perspective, these are the big boys and girls of the New Zealand climate scene, if you like. So there's a selection of causes of action in this case. There's public nuisance and negligence, both of which are struck out in the High Court. Mr. Smith is not allowed to proceed with these claims. We'll talk a little bit about that in a minute. But what survives in the High Court is what I've called here the innominate tort of uncertain elements, and that's a little bit unfair. I'll actually show you the pleading in a bit. And I know that one of the plaintiff's lawyers is on this call, so I'm not being rude, but it was basically a climate change tort, urging the court to say that you need to develop its own tort of climate change. The case has been appealed to the Court of Appeal, and we can go through the causes of action. And Jason's just finished off by looking at I suppose, what he would call the policy considerations. And perhaps the most significant feature of this case is what I call the Court of Appeal institutional concerns. And I don't think it's a surprise that these concerns are being phrased in the way they are by David Goddard, who's a relatively new member of the Court of Appeal. I think these reflect long-standing concerns that he has had about the ability of the tort system to provide systemic solutions to problems. That the basic problem in this case is only a small set causing Smith harm. Ultimately, in New Zealand, what's happening to Smith's land is being caused by people in China or in the United States, or frankly, by Australia exporting its coal to wherever it's being exported to. That's the reality. The aim of the litigation was not to stop emissions, but in fact, to get to net zero emissions. That sounds to David Goddard like a regulatory system. Regulatory systems can't be designed by courts, at least in our tradition. And the ad hoc nature of litigation means you're not going to have the right people in front of you all of the time. You're going to have cases, it's going to be iterative. It's just not going to achieve the kind of result that you want and that ought to be achieved through regulation. So the most important part of the Court of Appeal judgment is that really this is too big a problem for the law of torts. And this shouldn't really be a surprise for overseas people, because New Zealand's famous for anything in relation to the law of torts is the fact that we abolished the law of torts in relation to personal injury. We don't believe the law of torts works for the thing that it does in most of the rest of the world, which is to adequately provide compensation for personal injury. Why would it possibly be useful in another area? That's a little bit of an odd picture of New Zealand tort law, because in fact, New Zealand has a split personality in relation to tort law. We don't have a personal injury, but we have an extensive tort-based regime regulating the construction of buildings, with the major way in which we insure buildings, in fact, in New Zealand against negligent construction, is through making local authorities liable for their negligent inspection. So we do have some regulatory experience, and it's not an accident, I think, that much of David's appellate work had focused on trying to limit the liability of local authorities in tort law for their negligent inspections, very much on the basis this was a regulatory system that didn't work. So he's applied that logic, I think, to the climate change litigation. Negligence duty issues. The court accepts that there's foreseeability. However, it rejects that there is proximity. And I just highlighted the bit, and I think this is quite similar to what Jason was highlighting in relation to the decision in Sharma, that there's not enough factual link between the plaintiffs and the defendants. That just doesn't work. There's just not enough connection. There's just not enough reality that they're causing direct harm, if you like. There are a number of technical things which, if I were doing a New Zealand torts lecture, I would be very draw attention to. It's really interesting that they use this as a means of striking out a proximity claim. I don't think this has happened in appellate cases in New Zealand before, where we have made an assumption based on the relationship between parties as a justification for striking out a negligence claim. The tradition in New Zealand has been, particularly under the previous Chief Justice Elias, was to let cases go to trial before the courts would consider whether there was a sufficient relationship. So the most striking methodological thing is the court appeared to strike the case without doing that fact-based. And I think the plaintiff's lawyers are not very happy with that. But there are also problems with causation. Smith would have suffered the same loss. The basic problem is that he doesn't satisfy really basic but-for causation. He would have suffered the same loss, or will suffer the same loss, regardless of whether New Zealand is emitting a single atom of carbon, because of the reality of New Zealand's contribution to global climate change. These are big emitters in New Zealand, but the reality is it's unlikely that stopping them will stop the seas rising. The plaintiff had a number of different theories. This isn't really a tort methodology seminar, but They try a number of fancy words, fancy theories. The Court of Appeal rejects all of them. The Court of Appeal says in the end that the problem here is that you don't have all the defendants. You don't have all of the people who are causing harm. You have a small fraction of those people, and it's not conceivable that they have caused sufficient harm. And the other traditional cause of action, which is probably more likely to succeed in the Supreme Court, in my view, than the negligence claim, is public nuisance, which is very much, in our tradition, a public ugly duckling tort. Nobody really knows what it is. Nobody really knows what it really means, but that it undoubtedly exists. It's one of these great common law things that it's in the books, but it hasn't typically been viewed very much in the recent past. So there's a number of ideas that you're affected just as everybody else is affected, but that you have the ability to prove some kind of special. And David Bullock, one of the counsel in this case, has written a very good article about to be published in the Modern Law Review, saying it's actually about particular damage, that you've shown that yes, this is suffered by the public in general, but there is some particular consequence to you. And so in the Smith case, the particular consequence would be we're all affected by climate change, but Mr. Smith is a traditional owner of a beach, of a foreshore, which will be hurt by the rise in water. So he suffered a particular damage. The Court of Appeal doesn't reject that argument. I think it kind of moves on from that because, again, the problem remains causation. And I won't make you read all of those, the big observation, but in the case, the plaintiffs are attempting to draw on a number of 19th century polluted river cases back from the times of industrialization in England, where people at factories are discharging into rivers. The courts in some of those cases stopped factories or allowed proceedings to continue, even though all of the polluters were not necessarily before the court, or it was not entirely clear what the polluters were contributing. You can see the analogy to the climate change litigation. But the real problem still remains, just to get back, the real problem still remains, I suspect, in the public nuisance problem for the plaintiffs is the relative minimal nature of the New Zealand contribution to climate change in general. This isn't a situation where you have 5 people polluting a river. You can identify the 5 people, or the contribution that someone's making is significant. The difficulty is always going to be the relative insignificance. The novel tort just gets rejected. This is the pleading, but there's some sort of tort, a breach of duty that is designed to prevent climate change. And I won't talk about that very much. The court is, I think, a little bit unfairly scathing of this. It's really, if you haven't put enough flesh on the bones, and I feel the pain if one of the counsel is on the call. But basically, I think they're basically saying we just can't do this. Common law courts just can't invent something. Maybe the Supreme Court will do that. And the reason they may do this, or they may change, is what this case is really about. And I think this is the most significant part, which is not really explored in the High Court or in the judgment that Justice French wrote, which I think is in the High Court of Appeal. It is in the fact that Mr. Smith is Maori, that he is representing Maori interests. So tikanga Maori is the concept which reflects custom and also reflects those part of customs which we would consider to be law. And if there is a revolution happening in New Zealand law, it is this, that not everybody, but there are certain people that don't, obviously. But there are very few judges who are not going to write in their judgments that it is not accepted as, quote, the first law of New Zealand. First is always ambiguous. Does it mean the law that was here first, or does it mean first in terms of rank? But it's certainly accepted now as part of New Zealand common law, whatever New Zealand common law is, and that's another seminar we could do. Part of New Zealand common law. But one of the things that's going on in the Supreme Court at the moment is, what does this actually mean? Does this mean you use Maori values or you use Maori rules to tinker with common law rules? So you could tinker with the special damage requirement. You could tinker with proximity and negligence. The more fundamental thing, we wait on judgments that are still in the Supreme Court is whether, in fact, rather than just tinkering with rules, it enables you to completely recast what you're doing. That if tikanga is part of law, you might want to say, well, actually, if it is the first law, you should reformulate things completely, not just tinker with the rules. And I will start, I'm just about finished. I know we need to get on with Liz, but I think this is just really interesting. So in the Court of Appeal, the plaintiffs added a kaitiakitanga pleading. Kaitiakitanga is a very familiar concept to New Zealanders, to all New Zealanders now. It is a concept of guardianship, as it says there, that people are stewards, that our role is to protect rather than to just exploit, to renew rather than just take. And this is a concept which is well enshrined in New Zealand statute law, as well as being a principle of Maori customary management of Maori resources. It's a principle of New Zealand law in general. And the court takes this as being an invitation to develop the law to reflect kaitiakitanga, to say, well, actually, maybe we need to do things about New Zealand law which may not be so focused on the actual harm quantifiable, but perhaps which might emphasize the role of all New Zealanders, in particular of large companies which do emit a large amount of carbon, to protect and sustain the land on which they are based. And I think that that argument has real legs in the New Zealand Supreme Court. It's not developed perhaps as much as it could be at the moment, and it might well be that the New Zealand Supreme Court does not want to give effect to this without actually getting proper informed Maori submissions. There's a process we have in New Zealand for getting statements of tikanga, of customary law, but this seems to me, if there is to be a successful verdict for the plaintiffs, this is the most obvious route. And it depends how radical the Supreme Court is going to be in terms of what it thinks about the place of tikanga in New Zealand law. It doesn't mean that they're home and hosed, because of course there are two ways you could fulfill this obligation. One would be to change the common law. The other would be to emphasize that this is a public law obligation which is owned by the Crown and what we call koanatanga, the obligations of government. And you might still have the same debate. Is this a debate between what should be done in public law and the beehive across the road from me, or is it something that should be done in the High Court, which I can brag is just in that direction, the same distance Parliament is? That's the choices that are going on in New Zealand. I've probably gone too long, so sorry, Liz. I'll hand over to you quickly.
Utterly no need to apologise. Thank you both to Jason and Geoff for really fantastic sort of overviews of two really legally complex cases. So where I want to start is a story. So many, many years ago, I was sitting next to one of my colleagues at a dinner, and he was describing his theory of an area of private law. And it was beautiful. There were rights, there were duties, they were all in balance. It was coherent. And finally, I turned to him and said, your legal world is not my legal world. I have a legal world where public and private law are intertwined, where there's lots of different pieces of legislation. There's delegated legislation. There is soft law. There are different doctrines from different areas of law connecting to each other. Now, the reason I tell you this story is because environmental law and climate change law is often not thought of as law. It's thought of as politics, and it's thought of as policy or science or something else. But what Jason and Geoff's presentations highlight is this is very much a legal world, and this legal world is not going to go away. So I really have a set of comments which I've divided into kind of three different areas. First of all, I want to talk about how should we think about these cases? How as lawyers do we kind of characterize them? Secondly, I want to discuss why climate change is giving rise to these complex kind of legal issues that we see in these two cases. And third, I want to reflect on this idea of legal imagination, and then I have some conclusions. So first up, how as lawyers do we think about cases like these? The tendency has been to describe this as climate litigation. To me, these cases are about climate change adjudication. These are about the substantive law and how law and legal ideas are applied to a problem that law hasn't encountered before. When we describe these as litigation, what we do is we kind of other this. It is immediately described as something which is to do with other reasons for bringing the cases, except all cases that are brought to a court are always brought for other reasons. So in terms of adjudication, what is going on in these cases? Well, and here I'm not just talking about Sharma and Smith, I'm talking about all the kind of climate change cases that we're seeing across the world. Well, first up, cases are about institutional failure. And I think Sharma is a prime example of this. Massachusetts and EPA in 2007 in the US, or the Juliana litigation in the US. These are cases because governments have failed to respond to climate change. And in this regard, I would note that Australia is striking at the federal level because while Victoria has a very impressive piece of climate change legislation, there is none at that level. But these cases that are emerging are also about what I've described with Scotford and Barrett as expository justice cases. These are cases also about making clear what is the law in light of new laws, in light of new problems. And an example of this would be the recent Heathrow case before the UK Supreme Court. In that case, it was, well, what does Section 5.8 of the Planning Act 2008 actually mean? And finally, and perhaps most importantly, and this is in a sense really the future of how lawyers will need to be thinking about climate change, these cases are about dispute resolution. Climate change is a complex problem which is going to give rise to lots and lots of legal disputes and is already doing so. Disputes over what the law is, what are obligations to each other. And an example here is the case which was heard earlier this year in the US Supreme Court, the West Virginia and EPA case, which is about what powers exist under the Clean Air Act. But the important point is if we keep seeing these cases about litigation and not adjudication, we don't see the substantive legal issues that are coming up and which Jason and Geoff so fantastically outlined. Okay, so that's my first point. This is a legal world and it's a complex legal world. My second point is, well, why is it? And here it is often said, and a piece I did a couple of years ago with Scotford and Barrett, is climate change is disruptive. Disruptive is one of those lovely words we can throw around. What do I mean by that? Well, I mean three different things. First of all, the type of problem that climate change is different from the type of problems that we are used to dealing with. I have in my writing described it as hot. And what I mean by that is taking from the work of the economic sociologist Callan, is that a lot of situations we deal with, we know who the parties are, we know what their interests are, and we kind of know what are the relevant facts that we should be looking for. They're cold situations. Contract law is a fantastic example of a cold situation. But in hot situations, we don't know who the parties, the necessary parties are. We don't know their relationships. There is a contestation over what is relevant interests. And it is often the facts are highly contested, although as Jason quite rightly noted in the Sharma case, and I think this is also the case in the Smith, that there isn't actually much disagreement about the facts here. And what that means is, in a sense, as lawyers, we're trying to figure out who are the parties who we think have legal interests and who are the parties, to put another word, who you just say, oh no, that is not legally possible. And I'll come back to the significance of that, but we can see that in both the reasoning in these cases, struggling with, well, how do we as lawyers think about this as a legal problem in light of all these things? The second reason why climate change is disruption, and it's not something we see in these cases, is of course where actually governments are taking action. A couple of years ago, I did a very nerdy piece reading all the cases about judicial review of wind turbine planning applications in the UK. Now, why are wind turbines being built in the UK? Renewable energy to help deal with climate change, but that's a new kind of development, very different from the kind of planning developments we've seen before. And the courts have had to develop a new body of doctrine to deal with that. And the final form of disruption we see, which again is not in the Sharma or the Smith case, is where legislation has been introduced to, in a sense, respond to climate change. The emission trading scheme at the EU level is one example of this, or if I go back to the Heathrow case, in the Planning Act 2008, Section 5.8 and Section 10 are explicit statements about taking climate change into account. And so courts are having to think about, what do these actually legally mean? So we're dealing with all these different types of legal disruption, and they will be dealt with for many decades to come. But what we see, and I take the example of the wind turbines, is while you might have a spate of litigation, as the case law, as the doctrine becomes clearer, that litigation, that need for dispute resolution also kind of tapers off. Okay, so that deals with the last point. Apologies for the bell. I'm right next door to Merton Chapel. So it keeps the time for me. So how as lawyers do we think about this? And this is where legal imagination comes into view. Now, some might think cynically legal imagination is a contradiction in terms. It's not. What I mean by legal imagination is the mental constructs that we as lawyers use to think about law, to reason with law. If I say the word rights to Jason, a certain conceptual idea will pop into his head. Legal imagination is, these mental constructs are what we teach in law school. It's what we use to constrain legal thinking, but it's also what we use to empower legal thinking. Legal imagination will exist in different ways, in different legal cultures, but it is fundamental. Now, my argument is that this disruption caused by climate change requires us to expand and evolve legal imagination. Now, let me stress this word evolve. This is not about abandoning law, which is often what we see in some, law is not fit for purpose, so we need to replace it with something else. It is about showing how legal reasoning can evolve in light of new circumstances and new law. And what I want to highlight in these cases are three different examples of how that is happening. The first is statutory interpretation, and this comes to the Sharma case and the Environmental Protection and Biodiversity Conservation Act. A carrier bag of an act, if there ever was one. You might say that Sharma case is long, that act is also very long. And really what we see both at first instance and in the court on appeal is the courts attempting to make sense of what in actual fact is a complex piece of legislation because it is shaped by the federal government's constitutional competences in relation to environmental issues. Now, to me, the issues in that case about how do we think about the overall purpose of the act? Do we think about section 130 and section 133? How do we construct this act is a feature that we see, and that kind of statutory construction work we see in many climate change cases. Indeed, a paper I did back in March, my opening line was, it is a truth grudgingly acknowledged by environmental lawyers that many climate change cases are statutory construction cases. Now, I highlight that because while academic lawyers tend to, the word statutory construction makes the heart sink, we of course have many lectures from judges in common law countries constantly reminding us that statutory construction is far more important than is often recognised by academic lawyers. So this expansion of legal imagination is not something radical. It's actually about saying, yes, here comes the time to take legislation far more seriously in our legal reasoning. My second point is to do with doctrine, and this comes to, I guess, Jason's point about how long Sharma is. What is striking about Sharma, again, both initially and in the, on appeal, is how much the judges are working, in a sense, with first principles. I'm using that word lightly, not technically, to think about how does tort law reform? How do we think about tort law in light of this new problem? And of course, what we see are different approaches, and you know, Jason is saying, well, it should have been this way or not that way. But it is this kind of reflective process of how do we think about this doctrine. Now, I think we see that less so in the Smith case, and I'll come to that. But that, again, is something we can see in many of these climate change cases. Some of you may have come across a case called Juarez, which is a kind of extraordinary case brought by a Peruvian sort of guide and in the German courts, arguing under the German civil law that his property in Peru has been interfered with because their emissions have led to increased flooding risk in the Peruvian Andes. And it's a case that at first, when I first saw this case, I thought this is a ridiculous case. But of course, and that at first instance, it was thrown out. But on appeal, what you see is the court reflecting on that provision of the German Civil Code and saying, by analogy, you know, how we might be able, you know, this is actually arguable. And at the moment, the case is at the kind of evidentiary collection stage. And so here, in working with doctrine, and this comes back to Jason's point, lawyers are using the things in their repertoire of legal reasoning, analogy, metaphor. As Max Del Mar has pointed out in his fantastic book on legal imagination, these are important cognitive and legal reasoning skills. Now that brings me to my third point about legal imagination, and in a sense, I think the most significant. What we see in both cases, and this was both highlighted by Geoff's and Jason's comments, is the way in which these issues, such as climate change, are often put in another box. So we say this doesn't go in the legal box, this goes in the politics box, or this goes in the policy box, as if they are fixed boxes and we all know what they are. But in actual fact, we as lawyers are shaping what we understand as those terms. We are needing to understand what we mean by those. And I think it's striking, and here's my really provocative point. I think actually probably tort lawyers have a better understanding of what they mean by policy than public lawyers do. But what we need to see in these cases is that law is framing understandings of these things, and we need to know what is policy and politics if we are going to rely on this in our legal reasoning. Okay, let me come to my conclusions. As Jason rightly highlighted in this case, the facts, the facts were not under disagreement, but that does not mean that this is not a different type of problem that tort law is used to dealing with. It is a hot problem. There is this complexity about how do we think about the fact, if this affects everyone, who can bring this to court? If we're all contributing, can law actually identify those parties which they should say are legally responsible? And in that regard, Justice Preston's comments in Gloucester about the drug dealer defence, about this argument, just because, a drug dealer can't use as a defence saying, well, if I didn't do it, someone else would do it. So the first point is to say, this is sort of factually clear, but also factually complex. The second point to make is at these points in time, there is a danger of creating a binary where suddenly law becomes fixed and we say, this is the law. And if we're going to be legally rigorous, we must reason this way. And thus the only way forward is to kind of radically depart from the law. And we can see that in some approaches by academics. And if we go back to the New Deal in America, we see that binary as well. And in my mind, that is not helpful. And finally, I will refer to Justice Beecher's at the end of his judgment. He talks about this idea about how, at first instance, a seed was planted, an idea. And guess my final point would be to say, and we as lawyers need the legal imagination to not only cherish that seed, but to help it grow. Thank you very much.
Can I conclude by very special thanks to all three of our panelists and make the comment that not only were all of them very informative on the topic that is, of course, as important as any in this day and age, but also they were very provocative. You really did stir us up to think hard about things that we may all be taking far too much for granted or all assuming far too readily. And in that way, I think have opened up the prospects for continued work and debate in this area. So I'm not sure in this medium how we do it, but can we, by whatever way is possible, express our gratitude to all three of our speakers tonight. With that, I close the proceedings. So thank you all.